Legal SA takes legal action against IEC on what they say their shortcomings regarding commitment to investigate the over 150 million Ezulwini debt settlement agreements, as well as announcing new complaints to the IEC against the EFF and MK. Let's talk about it. Hello, welcome to Entertainment's Galore, and this is your girl Missy. Please do like this video and subscribe to the channel. So ActionSA today had a press release, right? However, I will be referencing from their website, posted or rather written by Michael Bermans, who's the ActionSA national chairperson. And I quote, "The decision to take these steps arises out of an increasing concern that the Party Funding Act is being rendered meaningless by non-adherence to provisions of the Act legislation that places the onus upon a party to self-declare, and the reality that the IEC is not set up as an investigative body." So to point out just how serious the problem is, the IEC recently took political parties to court, including the ANC, for non-submission of audited financial statements, which is the only safeguard against a party not disclosing a donation. The court imposed a fine of 40,000 rands on these parties, which parties like ActionSA spent double this figure on auditors to achieve a clean audit outcome 3 years in a row. The ANC and Ezulwini, alright, following the two-line statements issued by the ANC in December 2023 that the party had settled the debts with Ezulwini Investments, ActionSA has been in a protracted battle with the IEC investigates this matter purely on, or rather with the IEC to investigate this matter purely on the basis that there is no way the settlement can be lawful in terms of the Act. So they put it in point form. So point 1, a market-related interest from 2019 would have to have been levered, making the likely debts in excess of 150 million. The settlement should not legally be discounted by more than 15 million. The ANC only had 10 million in disclosures in the quarters under question, which the settlement was concluded, and had been in financial distress, unable to pay salaries for striking workers. Any donor paying on accounts more than 100K would have to be declared as a donation in kind, so such declaration was forthcoming. The settlement will require a minimum of 10 donors to settle accounts with disclosures, and no such disclosures were made. So it is necessary to observe that ActionSA has discovered that Ezulwini Investments is a registered vendor to at least one municipality in KwaZulu-Natal where it has been awarded tenders. A real concern exists that the real terms of the state settlements may well involve South Africans footing the bill for the settlement. And then ActionSA's efforts to engage the IEC to investigate this matter eventually led to correspondence from the IEC in March 2024 confirming they were handling the matter in terms of the Act, and no further communication has been forthcoming. So this is despite regular attempts from ActionSA to gain progress reports ahead of a 29 May election, in which South Africans had the right to know the full picture of party funding when they voted. So yesterday, the IEC legal team responded to a letter of demand reversing the earlier position and claiming now that there is no prima facie case to investigate. ActionSA's legal team will now proceed to initiate a two-part legal action. So firstly, to obtain the record of decision from the IEC, to assess the rationality of the decision. Secondly, if necessary, to challenge the rationality of the decision to decline the investigation. It is important to observe that the fundamental principles of administrative law require that the exercise of public power in this instance by the IEC in relation to this matter, be subjected to the scrutiny of the scrutiny that affords a litigant the right to assess how that decision was made and, where necessary, challenge the basis upon which the decision to refuse to investigate was made. The EFF and MK complaints, ActionSA has initiated a new set of complaints that were issued to the IEC yesterday in relation to the EFF and MK parties on the basis of the self-evident fact that their disclosures do not substantiate their campaigns. So, in the case of the EFF, 3.5 million was disclosed since the start of the 2022 to 2023 financial year in the context of an election in which EFF is estimated to have spent over 100 million on stadium events alone. Perhaps even more absurd is the disclosures by the MK Party, which, since its registration, managed to disclose of less than 400,000 rands in the context of an election in which it emerged as one of the most well-funded political parties, and a speculation of a foreign funding. ActionSA contends that the IC is not only the only situation in government empowered to investigate these matters, but that the IEC cannot wait for a party to self-incriminate before its legal obligations in terms of the Act kick in. So, if a political party demonstrably runs an election campaign that potentially and so substantially exists to disclose means of funding the campaign, then the IEC must investigate. ActionSA will follow the process with the IEC relating to the complaints filed against the EFF and MK parties, and will keep South Africans appraised of the IEC's response to these matters. And South Africans have the right to vote with the full knowledge and transparency of how parties are funded, and it is necessary for these steps to be taken to ensure that a right does not exist only on paper.